Hi everyone, good morning. Thank you all very much for joining us this morning for what is the first K3 Hub CPD webinar of 2025. For those that haven't met me before, my name's Marie and I'm a Managing Director at Quantuma. And on behalf of our parent company, the K3 Capital Group, I lead the K3 Hub, which is a member network for professional advisors developed by us and other companies within the group. First, I'm going to get 2025 underway with a bit of an apology. So to at least some of our members that have joined this morning. So we set out with on the front foot with very best intentions to get timely invites out for today's session. It looks as if one of our channels might have let us down, I'm afraid. So it may well be that some of you received a very late invite for this session. We weren't aware that one of the channels had let us down, and as soon as it became obvious to us, we did take steps to rectify that. I'm afraid that some of you will have had some late invites as a result. Those problems have been rectified, and we shouldn't experience the same going forward. So thank you for bearing with us, and for those that got a late invite, if you are here today, thank you. Before I move on to some housekeeping and introducing our speaker, I just wanted to flag one thing to the advisors on today's call, if I might be so bold. So we've got some pending changes to business asset disposal relief, or formerly entrepreneurs relief. I just wanted to flag that it's not too late for your clients to take advantage of maximising tax efficiencies, particularly in the shape of solvent liquidations before April 25, before the changes take place in April, sorry. If you've got any inquiries, you can get in touch. I think my email address will appear at some point, perhaps later in the session, and we will be in touch in the coming weeks about that. I just wanted to flag that. I'm sure you're aware anyway. Some pieces of housekeeping then. So we are recording today's session. I think you probably will have had that notice pop up on the screen. That will appear on the K3 Hub and the Quantuma websites next week. We have got course notes and they'll be placed into the chat periodically throughout today's session. Q&A function is open, so please do feel free to ask questions as we go. If you have got questions, it would be good if you could use the Q&A function rather than the chat, so that Tony, the speaker, knows where to look, and all of our questions are in the same place. I know that we have had some questions in advance of today's session. It's likely that we may not be able to get through everything today. If that's the case, we will pass them over to Tony and she'll come back to you separately. We are aware that today's session is quite long, so we do intend to have a couple of comfort breaks throughout the session. Tony will flag when they are. We are also running some polls today. These are anonymous and just for fun, to be honest. So do get involved. I think Tony will share those results on the screen. Right, so on to today's webinar then in that case. So I'm very pleased to be able to welcome back to the K3 Hub Toni Trevett, who's spoken for us regularly. Toni is a qualified HR practitioner, mediator, trainer and coach. She's a fellow of the CIPD. She also sits part-time to hear cases for the Employment Tribunal Judiciary. Amongst other things today, Toni will be covering what's new in employment legislation, key case law, and changes in statutory calculations. Just a quick word before I go then. So we do have a packed CPD and structured and unstructured series of events and schedule this year. We've got a full range of topics covering tax planning for OMBs, understanding the accounting requirements of LLPs, VAT, which is always very popular, a LinkedIn masterclass, commercial property taxes, again, another very, very popular session, and the ever popular autumn statement. Invitations are sent out on a regular basis, so do keep your eye on your inbox. We also promote these events on the K3 Hub website and the Quantuma website, as well as on LinkedIn. I've also got a brochure with the full programme for 2025, and we'll be in touch in the coming weeks with a copy of this for your records. So all that leaves me to do today is wish you a great weekend when it arrives. And Toni, over to you.
Thank you so much. And thank you for having me back again. As Marie said, we've got 3 hours today. I'll try and do the breaks on or around the hour, just so you know when to expect them. It's a year since our last update, to be honest, so there is plenty to tell you about. Lots has happened and lots is predicted to happen. So I've had a very nice introduction already, thank you. As Marie said, I work for the Employment Tribunal Service and sit part-time and hear cases as well as the work I do with organisations. So I thought we would start with a few interesting cases to look at, first of all. So we'll run through the agenda again really quickly. We're going to look at the past 12 months first. We're going to look at 2025 and beyond second. I'll touch on the statutory calculations that we know about. We haven't heard what all of them will be yet, but I can tell you the ones that are out there. And then we'll have a look at a few key cases as well. So I wanted to, as I said, I wanted to touch on a few headline cases. So often, and I'm sure you've thought this as well, you see these cases in the news and barely a week goes past without some organisation like the Times or some other newspaper or outlet publishing some great story about an employment tribunal claim, some element of discrimination or harassment often, and sometimes really large amounts of compensation as well. And these stories have that kind of attention-grabbing, sensational type headlines that some people would just describe as clickbait. So I thought, let's have a look at a few that have really stuck out and see how much truth there is in them. Are they more fact or fiction? So I've got a couple that really stood out to mention to you. So the first one, the headline was, "Calling women pretty at work is sex discrimination, rules judge." And this was a case brought by Miss Emma Nunn, who claimed that she was discriminated against by her employer when she was asked via WhatsApp to come to a meeting with a client because, and this is quotes, "they like pretty women." So she queried this with her boss and said, "Is the only reason that you want me to come to this meeting because the client likes pretty women? And if that is the case, I'm not coming." To which her employer replied, okay, just calm down, babes," which I'm not sure was massively helpful. Anyway, to cut a long story short, she later resigned and brought claims of constructive unfair dismissal, direct sex discrimination, sexual harassment, harassment related to sex, a whole range of cases and claims. Anyway, the Employment Tribunal heard this case and they found that the pretty woman comment, neither that nor an equivalent would ever be said or made about a man, about a male colleague's physical attractiveness as being a reason to be invited to a work meeting. And for that reason, they found the comment was demeaning and patronising and unwanted and was only made because of her sex. So that did amount to direct sex discrimination, and she was successful in relation to that part of her claim only. In fact, all her other claims were dismissed. So in this case, then, the headline, whilst very attention-grabbing, was in fact an accurate report of the tribunal's decision, but only in one area of her claim. So that's the first one. The next one that stuck out for me, and this was the headline, "Teacher sacked for sleeping at the school attended by Prince William and Prince Harry, winning nearly £170,000 in an unfair dismissal case." So do you get £170,000 if you're unfairly dismissed because you've fallen asleep at your desk? Well, this teacher suffered from anxiety and depression and was actually dismissed as a result of poor attendance record, as well as some behavioural issues, including the falling asleep at school. But this was all found to have been caused by his mental health. And the teacher subsequently brought a claim for discrimination arising from his disability. And the tribunal did find that the school had acted disproportionately in dismissing this teacher, as they had jumped straight to dismissal and not properly followed their own capability, absence or disciplinary policies. In fact, I'm always saying this to clients: if you have policies, you have to follow them. The teacher was awarded, I think it was about 168,000 in damages. And interestingly, the tribunal noted that the school had initially been reasonably sympathetic towards this teacher. There were lots of great WhatsApp messages between him and the deputy head. There were various reasonable adjustments made. And the issue was that a lot of these acts were done informally rather than as a formal part of their process. So again, it highlights the importance of keeping good, accurate, paper trails, good notes, decisions should be clearly documented, and you should always be able to demonstrate that you've complied with your policies and procedures. So essentially, the tribunal found that Mr. Smith had a disability, and that the reason for his dismissal was almost entirely because of that. In fact, I think in the judgment it said something like sleeping at work was due to the medication and sleep disruption caused by the disability. In that case, anxiety and mental health issues. So, you know, you do have to step pretty carefully when you've got someone with health-related issues that relate to a disability. So, you know, while sleeping at his desk was one of the reasons this person was dismissed, it wasn't the whole story, and his disability was the reason. And so the headline, whilst technically probably accurate, is a little bit misleading, I think, in that case. The next one I liked was HMRC boss sends worker unwanted birthday card, which was harassment. So is a birthday card, or could a birthday card be an act of harassment? Well, in this case, this employee went on sick leave due to work-related stress on this example. And she had expressed to her manager that when she was off sick, she didn't want correspondence, if at all possible, or that should be kept to an absolute minimum. And if she had to be contacted by anything, it should be an email only. However, she was contacted almost every other day by text, phone, and emails asking for updates on her health, when she would return to work, and so on. And she was also sent a birthday card around her birthday, even though she had previously objected to that and had asked to be removed from the team's birthday list. So she brought 3 employment tribunal claims in the end, and they had about 20 different allegations of race and disability harassment, as well as discrimination and victimisation. And the tribunal found that the HMRC's conduct in repeatedly contacting her during her sick leave was an unwanted act. And it found that 10 of those allegations of harassment, in fact, were well-founded, including being sent a birthday card. So it wasn't just a birthday card, after all, so the headline might be a little bit misleading, and there's probably no reason to panic and never send another work colleague a birthday card again. But what's important is this person really specifically asked to be removed from that birthday card list. And so we've got to make sure that when people do these things or make these requests, that we comply with them. Just 2 more to tell you about. The next one really caught my attention, and the headline was mispronouncing a name breaches equality laws. And this is a case with Mr. Taniji, who sued his former employer for unfair dismissal and harassment on the grounds of race and direct discrimination after a colleague repeatedly called him by an incorrect name. And the tribunal found that it had no jurisdiction to hear his unfair dismissal claim because he didn't have enough service, but his claim for direct discrimination was also dismissed. However, regarding being called by an incorrect name on 4 occasions, the tribunal found that he did have a genuine emotion and sensitivity about his name. He explained what his name meant in his Hindu culture, and he was very proud of it, and the tribunal accepted that this mispronunciation of his name by a colleague had the effect of violating his dignity and creating an intimidating, hostile, degrading, humiliating and offensive environment for him. And the tribunal said that amounts to harassment on the grounds of race, and he was awarded £9,400 for those 4 occasions of mispronunciation. So the headline in this case was, in fact, correct. And then the last one, and some places I find very hard to identify with, and this would probably be one. The headline was, breaking wind on colleague as he eats lunch was age discrimination. Pretty attention-grabbing, yes. So a manager for Birmingham City Council in his 50s found it very amusing to break wind on a younger colleague while he was eating his lunch. And eventually this younger colleague resigned and claimed constructive dismissal and age discrimination. The tribunal heard that this chap had threatened this younger colleague whenever he objected to this disgusting behaviour, and would say things like, you need to be careful how you speak to me, I can just get rid of you. You're only a trainee, I can get rid of trainees like I have others in the past. And in a somewhat unfortunate turn of phrase, the junior colleague actually told the tribunal, when he caught wind of my progression plan, no pun intended, I'm sure, that's when I first started to feel really uncomfortable around him. So, you know, he would make comments like, all these babies coming in and trying to take over, you're only a pup, I've got kids your age, it's last in first out at the council, so I won't be the one to go. If any of you youngsters get a job above me, I'll be telling you all to F off. You know, pretty unpleasant stuff by the sounds of it. So the Employment Tribunal found that there had been an unfair dismissal, there had been age discrimination and age-related harassment, even though some of those discrimination claims were out of time. What the headline admits is the fact that the claimant had raised other complaints about this older colleague's behaviour and evidence, and some of those were pretty awful, threatening behaviour. But the headline only picked up on that one part of this case. So it perhaps goes without saying that if this manager had broken wind over all the colleagues, not just the younger ones, then it wouldn't have been age discrimination, although, of course, it would have been rather serious acts of gross misconduct. But there you go, it was correct, but it wasn't the whole story at all. So I suppose my point on these is, when you hear these headlines or when you read these headlines, you know, they're not always entirely accurate. They very rarely tell the whole story. It's probably unsurprising that most are meant to be attention grabbing and have to simplify the issues to get your attention, really. But you can always read the whole of Employment Tribunal decisions at the gov.uk website. So if one gets your interest, piques your interest, go and download it and have a read and see if there's more to it than just the headline would portray. Anyway, there we go, just a few that caught my attention. So let's start with a quick recap of 2024. It was a very eventful year in the employment law world. So I've got a very quick whistle stop reminder for you. So first of all, in January, we had an updated code of practice on flexible working. So ACAS updated its code, and that code incorporated all the changes that were coming into law from April 2024. And it's really important that the code of practices are followed if there are any statutory requests for flexible working. So if you're not sure about your own policies, then go and have a look at the code, read your policy, and then make sure that they are compliant. So that was in January. Then in March, we saw the annual update to the Vento bans. These are the bans that establish the award an employment tribunal can make to compensate a successful claimant for injury to feelings. So it only relates to discrimination cases where people are successful. And it's that sum of money that's paid in addition to any loss of earnings and other awards. So I set out there on the slide what the Vento bans went up to last March. We haven't heard whether there's going to be any changes this year as of yet. Okay, then we saw changes to paternity leave. They changed on the 8th of March 2024. We have the paternity leave amendment regulations, and they apply in all cases where the expected week of childbirth falls on or after the 6th of April, or fell on or after the 6th of April 2024. And primarily it allows paternity leave to be split into 2 blocks of 1 week at any point in the first year after the baby's birth or the first year of adoption. So a big change to the paternity rules. And for parents or babies, for parents of babies born after the 6th of April, fathers or partners are able to take 1 continuous block or 2 separate weeks. So I've set out on this next slide very simply what the changes are. And as for notice, employees still have to give 15 weeks notice before the expected week of confinement, that's the EWC, or if that's not reasonably practical, as soon as possible, for when they want their entitlement to take leave. But they don't have to confirm exact dates until 28 days before that period of leave is due to start. And I realise sometimes that's not very easy. And on the most part, I think employers are pretty pragmatic and helpful for people. But quite a lot of change to the paternity rules. Then moving forward a bit, from March we get to April, and we saw the introduction of carers leave. So this took place on the 6th of April 2024, where employees had a new right from day one, so no minimum service requirements, to have a week's unpaid carers leave every 12 months in order to provide or arrange for the care of a dependent with a long-term care need. And that leave can be taken in single or half days. There's a notice requirement of 3 days or double the length of leave requested, whichever is longer. So if you want 3 days carers leave, you would have to give 6 days notice. If you want 1 day's carers leave, you would have to give 3 days notice, because that's the minimum. So there's lots of rules about this. The definition of dependent, for example, mirrors the definition used for the right to time off for dependents. So spouse, civil partner, child, parent, a person who lives in the same household other than a tenant or lodger. And then there's always the catch-all provision that says, or any other person who reasonably relies on that employee for care. And an employer can't refuse this leave, but it can be postponed where it's reasonably believed that the operations of the business would be unduly disrupted if the leave were taken at that time. However, the leave would have to still be given within 1 month of the original date requested, and there's a counter notice process for that. And as with other statutory leave entitlements, an employer can't penalise any employee who chooses to take advantage of carers leave or any other family-friendly type leave entitlement. So if an employee were to be dismissed for a reason connected with taking carers leave, it would be automatically unfair. And of course, the person's entitled to come back to the same job after their carers leave. So hopefully you've all introduced policies that relates to carers leave, because it's nearly a year since that came in. Then we saw, all still in April, the Protection from Redundancy, Pregnancy and Family Leave Act. So redundancy rights for employees on maternity leave when pregnant, or for those returning from family-related leave, changed on the 6th of April and gave greater protection for new parents, essentially. Under the previous legislation, employees on maternity leave, so they had to be on maternity leave, shared parental leave or adoption leave, had special protection in a redundancy situation. So the law already gave special protection if you were on that leave when the redundancy was taking place. And that special protection was the right to be offered a suitable alternative vacancy, if one is available, before being made redundant. So it essentially gives employees on that type of leave priority access to redeployment opportunities over and above the ability to leapfrog other potentially redundant employees because they are on maternity leave, shared parental leave, adoption, and so on. So what this legislation did last April was extend that protection even further. So I've tried to summarise it on this slide. I've set out some of the detail of that extended priority status for redeployment opportunities in a redundancy situation. But essentially, it extends the priority status given to those employees, not only while they're on the leave that they've taken, but also if they've recently returned from maternity, adoption, or shared parental leave. So it essentially extends that period of protection and allows people to have priority access to redeployment opportunities. So what it might mean is, imagine someone's on maternity leave, their position is redundant, but there are suitable alternatives available. Let's say they're in a pool with maybe 8 other employees, all wanting a redeployment opportunity. Well, that person on maternity leave rises to the top of that pool and becomes the priority status. So if there's only 2 jobs available that those 8 people could be suitable for, one of those 2 jobs will go to that person that was on maternity leave. So that's essentially what it means. So watch out for any maternity or shared parental or adoption or any of those family-friendly leave issues where you're making people redundant. Don't forget that there is this priority status and it has been extended where there is a redeployment opportunity. Okay, good. Moving on. I talked quite a lot last time about all the changes that affected holiday pay and holiday entitlements. And I'm not going to repeat them because there are far too many. But, you know, the main ones, just in case you missed it, from last April were the introduction of the 12.07% calculation method when determining holiday pay for any individuals with irregular working hours, seasonal or even part-year employment. So number 1 was the reintroduction of the 12.07% calculation. Secondly, the reinstatement of rolled up holiday pay for individuals with irregular working hours, seasonal or part-year working, so the ability to pay as you go. Thirdly, there were modifications to the rules regarding what unused holiday you could carry over. And then lastly, there were some adjustments to the definition of a week's pay for the computation of holiday pay. So if any of those are relevant and you're not sure whether you made the right changes, go back and have a look and just double check. The changes came into force on the 1st of April 2024, but will only apply to businesses whose leave year started from the 1st of April 2024 onwards. So those with January to December leave years were not impacted until the 1st of January 2025. So it's also dependent when this takes effect as to what your leave year is. So any of you with January to December, it should have taken effect on the 1st of Jan this year. Also last April, we saw the normal annual increases to tribunal awards, national minimum wage, national living wage, or the family-friendly rates, and so on. So I'm not going to take you through those because they're all changing this April. Excuse me. And then I already mentioned the new code of practice on flexible working, but what we saw the law change on the 6th of April when the right to request flexible working was altered. So employees now have a day 1 right to request flexible working, used to be 26 weeks continuous employment. Employees are able to make 2 flexible working requests in a 12-month period. Before that, it was only 1. Employers will be required to deal with requests within 2 months of them being made. Previously, it was 3. There is extensions that can be agreed. Employees will not have to explain within their application the effect that acceptance of their request might have on the business or how to minimise that, which used to be in the previous legislation. And employers are required to consult with an employee before they are able to refuse a request. So the Act doesn't create an automatic right to work flexibly. It remained one of being able to request to work flexibly. It just changed what those rules were. And employers are not required to offer a right of appeal to an employee whose request has been rejected, even though it's recommended in the ACAS Code of Practice. It's not in the legislation. I personally think you should give an appeal just to be as fair as you possibly can. The reasons that you can reject a request didn't alter, and I've just put them on a slide as a reminder. And getting it wrong can be really expensive when it comes to flexible working. It's not so much that a breach of the flexible working regulations, because the award is really small for that. It's whether that request was actually connected to, gender, for example. Was it someone returning from maternity leave who's making a flexible working request? So that's why we have to be, really careful with them. I've got a question for you next. I wonder if that can go up. Does an employee have to say why they are making a flexible working request? So I told you the things that they don't have to say anymore, but do they have to give their reason for making a flexible working request? So very simple, yes or no. I'll give you a few seconds just to decide. And then please share the results when we've got those choices back in. So, excuse me, looking sideways, the results have come up on another screen. So we've got yes, well, pretty even actually. Yes, you have to say why, it says 46% of you, and no, you don't, say 54% of you. So pretty close. And the answer is, in fact, no, you don't have to give a reason when you make a flexible working request. People often do, but there's no requirement. They're not obliged to say why they make their request. But to manage the request appropriately, I don't think it's unusual for an employer to want to know. I mean, this definitely helps you explore compromises, and also to make sure, most importantly, that you don't inadvertently manage that request in a discriminatory way. So under the flexible working regime, even though employees are not obliged to say while they're making the request, to manage the request appropriately, I don't think it's unreasonable to ask. Of course, if it relates to childcare, or is it a reasonable adjustment? Is it a pregnancy or maternity returner? Is it a health and or disability related reason? There's discrimination protection in all of these examples. I even had a case where the employee asked to change their working hours so that they could attend regular religious services. And of course, by revealing that information, it connects it immediately to the protected characteristic of religion. So reasons can be helpful, obviously, in order to find solutions, but it can also raise issues of protected characteristics and less favourable treatment. So no obligation, pretty sensible, people often do, and you shouldn't inadvertently discriminate. Okay, then moving to May last year, we saw the Labour government publish its new deal for working people, and that was called Labour's Plan to Make Work Pay. And they set out that their mission was to grow the UK economy, raise living standards, introduce legislation in Parliament within 100 days of entering government. They've said that they would end one-sided flexibility, ban 0 hours contracts, end fire and rehire practices, lots of bold statements, and we'll look at what's actually happened with some of those shortly. There was a significant election campaign, as you know, in June, and then in July, after 14 years of Conservative leadership, we saw the Labour government come in and, quite frankly, have started to transform workers' rights. And the King's Speech also set out Labour's legislative agenda for the first months of government as well. New Deal for Working People, that was called. So we'll look at that in a bit more detail as we go through this morning. Moving on a little bit more, 1st of July 2024, we saw some key changes to the transfer of undertakings, protection of employment regulations, commonly known as TUPE. And TUPE is legislation that aims to protect employees' rights when there is a transfer of a business or a part of a business, or the change of a service provision. And TUPE sets out some rather onerous obligations including providing information and consultation to affected employees. There are hefty fines and costs awarded if an employer fails to adequately consult or comply with their legal obligations. So before July, under the previous rules, micro businesses, which are businesses with fewer than 10 employees, could inform and consult directly with the employees themselves if there was no pre-existing trade union or employee representation group already in place. And now more employers fall under this exemption because it's been expanded. So this is in England, Scotland and Wales. If there is no existing representation in place, then employers may consult directly with the employees if there are fewer than 50 employees. So it was 10, it's gone up to 50, or there are fewer than 10 employees affected in the organisation by that particular TUPE issue, by that particular transfer matter. So in both scenarios, direct consultation applies if there's no trade union or employee recognition group in place. In all other cases, we still have the duty to elect employee representatives or engage with trade unions, and that continues to apply. And this change was pretty well received by employers, to be honest, because it enables them to streamline the TUPE process and do away with the whole election stage, creating a quicker and more efficient process all in all. So my advice would be anyone involved in a TUPE type issue, in a transfer, in a sale, anywhere where you might think TUPE could apply, you need to really fully understand your obligations. It's the information and consultation which is very prescriptive. So when does it apply? What circumstances might TUPE be relevant? And what do you have to do if TUPE does apply? The reason I stress it is that a failure to comply with legal obligations under TUPE can result in up to 13 weeks of uncapped pay for each affected employee being awarded. So 13 weeks of actual pay, really expensive to get any part of TUPE wrong. So if you get involved in those kind of issues, make sure that you're really clear with what you have to do. Then a bit later, on the 18th of July, we saw the Statutory Code of Practice on Dismissal and Re-engagement, often referred to as the fire and rehire rules. This was introduced, the new code was introduced and took effect on the 18th of July last year. And this whole fire rehire piece came into the under the spotlight or on the radar because of the P&O ferry sacking, which you might remember maybe 2 or 3 years ago now, of 800 workers. I don't know if you remember, I saw the footage on the television with people being, forcibly removed from boats. So they sacked with less than half an hour in terms of notice over 800 people or nearly 800 people and offered them a way to return to employment, but on worse terms. So this is all part of this fire and rehire issue. And even though there's many good reasons why an employer might want to change terms and conditions of an employment contract, where the change is unfavourable or to the employee's detriment, particularly in relation to pay or benefits, and the employee in question might not give their consent to the proposals, then that's where we need to be mindful of this code. And if the issue can't be solved by consultation and negotiation, then an employer can terminate the existing contract and at the same time offer that employee a new one. And this is the fire and rehire process. The new code says it should be a last resort and that the purpose of the code is to ensure that an employer takes all reasonable steps to explore alternatives to dismissing and re-engaging in meaningful consultation with a view to reaching an agreed outcome with the employees and or their representatives. And the code sets out some really clear steps. It says that an employer must engage in meaningful consultation And that has to be for as long as is reasonably possible and in good faith. Although it's important to note that no minimum time period has been set. So as long as reasonably possible and in good faith, to have meaningful consultation. Secondly, it says employers are now required to share as much information regarding their proposals as is reasonably possible. The word reasonably features a lot in employment legislation. This information must also be shared as early as reasonably possible in the process, so that employees are able to understand the reasons for proposed changes, ask questions, and make counter proposals. And thirdly, the employers should revisit their business plans and take all reasonable steps to explore alternatives before going down a route of dismissing and re-engaging. And then the code further seeks to ensure that the employer does not, as a negotiation tactic, raise the prospect of fire and rehire unreasonably early. So you can't say, if we don't agree, we will terminate your employment and offer you a new contract in any event. It also makes clear that the employers shouldn't be threatening dismissal and putting any undue pressure to accept new terms. So one other interesting point, actually, which is very new from this, is that an employer must contact ACAS before raising the prospect of a dismissal and re-engagement. So that's a very interesting step that we don't have to do on in any other area of managing people. There's no requirement to contact ACAS. I understand this is a code of practice, but if you fail to follow the code, as we know now, because I'm going to explain to you what the change is more recently, any unreasonable failure to follow the code could increase awards by up to 25%. There was also quite a big fire and rehire case too, which made the news, which was Tesco's Stores Limited and Asda, the union. And this was where the Supreme Court upheld an injunction to prevent Tesco's from firing and rehiring a group of employees who had the contractual benefit to some enhanced pay, which had been described when given to them some years ago as a permanent enhancement. And Tesco's had offered this enhanced pay to a group of staff who were willing to relocate to a new distribution centre, and it was called the retained pay. And the terms of the retained pay were contractually described as permanent. Anyway, Tesco's some years later wanted to bring retained pay to an end and said if the employees did not agree, their employment would be terminated, but they would be offered re-engagement on the same terms, bar the retained pay element, which would be removed. Anyway, an injunction was sought by the union, and the Supreme Court upheld the High Court's decision that the right to receive retained pay should continue for as long as employment in the same role continues, and commented that this right is deprived of its value if there is nothing to prevent Tesco's from just terminating employment to defeat it. So pretty interesting case. So watch out for the code if you're ever thinking about using this fire and rehire process, because the code has lots of prescriptive steps that should be taken. And then in August, we saw the repeal of the Strikes Minimum Service Levels Act of 2024. So the government announced that it was going to repeal this act. It had only just been introduced by the previous Conservative government during all the industrial action that we saw, and it enabled employers to require a minimum level of service to be provided during a strike, which applied to specific services. And it was reported that the Act had not been used by any employer, had not resolved a single strike, even though it'd only been there for a very short period of time. So I guess, unsurprisingly, our new Labour government decided to repeal that. Then in October, we're nearly there for last year, we saw the allocation of tips legislation come into force. This was on the 1st of October. And this is where employers are required to pass on tips to workers. And this is employers of businesses where tips are left more than occasionally They're required to have a tipping policy in place, and the workers have a new right to request a copy of their tipping record in order to enable them to bring a claim to an employment tribunal if they believe they're not receiving the tips that they should be. Again, we've got a code of practice, which also came into force on the 1st of October. So again, lots of rules about how tips should be distributed, how the policy that you should have in place, the transparency of records, and so on. So if you work in a business like that, or with clients in businesses like that, we need to make sure we're complying with the tips legislation as well. And then we had a really big change. This was where employers have a new duty to prevent sexual harassment. And this legal duty came into force on the 26th of October 2024 in the form of the Worker Protection Amendment of Equality Act 2010. And it places a positive obligation on all employers to take reasonable steps to prevent sexual harassment in the workplace. It's only about sexual harassment, but that doesn't mean that we should ignore all the other types of harassment. The Equality and Human Rights Commission published some really practical guidance on this preventative duty and what employers should need to do or should be doing. And the guidance makes it clear that this preventative duty covers not only harassment committed by another worker or agent of the employer, but also extends to third parties. And it's an anticipatory obligation and an ongoing duty. So employers are expected to anticipate the risks for employees of sexual harassment within their businesses by conducting risk assessments, by taking action to prevent this from happening, i.e. to have good policies that employees understand, and then train them out, make sure that people know what's expected of them, and also to keep them under kind of regular review. And an employer who breaches this duty can face enforcement action from the Equality and Human Rights Commission. And if an individual brings a claim for sexual harassment, any compensation awarded can be increased by up to 25% if there's a failure to comply with this. So it's big news and it's important. I have to say, a lot of my training time since this became law has been training managers and training staff on, you know, what this duty is all about. So I know a lot of employers have taken it very seriously. So I'd be interested to know whether your organisation has changed its approach to sexual harassment training and education since October. I'm always interested to get a feel for whether people have taken note of this legislation or not. So simple yes or no for this one. I'll give you a second just to have a look, and then share the results when you've got them through, please. So here we go. Has your organisation changed its approach since October? A third of you, 33%, have said yes, but a rather substantial 67% have said no. Now, that could be that you've got great training and education already, obviously, and there's no need to make any changes. But, you know, I always say to people, just to have a look, make sure that you're happy it's fit for purpose. The reason it's important for an employer is that you can rely on a reasonable steps defence if an employee brings a discrimination claim. And what that means is that employees, when they bring claims, can bring a claim against their employer as one respondent, and the individual that undertook whatever acts of discrimination or harassment have taken place personally are named as other respondents. So it's really common for someone to bring a discrimination claim and say, I'm bringing a claim against, you know, ABC Building Company Limited and Joe Blogs, you know, whoever, the people that did whatever they're complaining about. So if an employer can show that they have done all they could do to eliminate discrimination from the workplace, they may be able to pass on the liability to the individuals, basically arguing, why should we be liable for rogue employees' behaviour, which goes against what we ask them to do, how we ask them to behave, the training we've given them, the policies we have. Why should we be liable when they're going against everything we've asked them to do? And if successful, then the employer escapes liability and it shifts to the individuals. And there was also a rather important case a year or two ago called Alley UK Limited versus Gellen, where the employer could not establish this reasonable steps defence in a case where an employee had discriminated against another. And that decision was taken because their equality and diversity training was stale and outdated. You don't really need to know the details of this case. It was a race-related harassment case. And it was one particular employee that carried out these acts of race-related harassment quite regularly. But it was also witnessed by various managers and other staff, all of whom failed to report it to HR or to take any action. So it was difficult to argue that the education policies and training was effective when all those people were not had not changed their behaviours because of what was happening. And the Employment Tribunal said, you've been unable to discharge your reasonable steps defence. It can't have been effective training if nobody that witnessed it or the person that was saying it thought they were doing anything wrong. It had become stale. And that was also because the defence was, it was only banter, which very, very rarely lands that well at the Employment Tribunal. It's very hard to say it was race-related banter or that was, disability-related banter. So there you go. Have to make sure that your training is up to date, refreshed periodically, not stale, and covers everything it needs to cover. So, beware the tick box exercise, because people often, don't pay the same attention, I think. Okay, good. And then in October, we saw the Employment Rights Bill be published, which is a massive, full shake-up of employment rights. The bill itself is, I think it's 158 pages long and has 28 individual employment reforms. And these are going to affect, 9 million workers potentially. So there's a lot of change in the Employment Rights Bill, and I've got a section a little bit later to talk to you about that. In November, the government issued an amendment paper to the Employment Rights Bill. It had some more changes. For example, they're talking about extending the time limit for bringing tribunal claims from the current 3 months to 6 months. So people will have double the amount of time to decide if they want to bring an employment tribunal claim or not. We'll talk about it in a bit more detail shortly, but the majority of the reforms in this bill won't take effect until 2026. So I'll try and explain all of them at least the most important ones to you shortly. As part of that, the government launched 4 consultations, which I've listed on this slide. They issued, I think it was 11 fact sheets, 23 impact assessments. I think it was reasonable to say that we knew at that point that matters were going to progress at pace and be pretty far-reaching. All those consultations have now closed. I'll be able to tell you more next time as to what those outcomes are. And that was 2024. So that's what happened last year. And of course, I met with you at the start of last year predicting some of this. So hopefully now that's all firmed up. So before we look at 2025, I think it's a really good point to have a quick break. It's 5 to 10. Well, on my clock, it's 5 to 10. So if we could just take 5 minutes, have a quick comfort break, put the kettle on, make a cup of tea, and I will see you back here at 10 o'clock. That would be perfect. Thank you very much. See you shortly. Welcome back, everybody. Hope you managed to take advantage of just a few minutes. Can see that there's a question coming in to the Q&A about the question is this tips or service charges added to the bill? And the legislation does refer to the charges will require employers to pass on all tips, gratuities and service charges onto workers without deduction. So it's not just service charges, it's all tips without deduction, i.e. without the employer keeping any of that sum. So thank you for that question. That's really helpful. Please, add questions to the Q&A at any point. So let's go on, and we're going to start looking at this year now. So 2025, let's start with what we know is definitely happening. So January 1st, fire and rehire, again, still more on this. There are, from this January now, higher protective awards payable. So as I explained earlier, there's this code of practice on the fire and rehire concept that we should follow. There is no standalone claim for a breach of the code of practice provisions. However, tribunals must take into account whether there are breaches to the code, if, for example, they're dealing with an unfair dismissal claim, because they are now able to bring a higher protective award if there are. So from the 20th of January, tribunals will have the power to increase any protective award it makes by up to 25% if the employer has unreasonably failed to comply with the relevant code of practice. And the uplift applies to the protective award, which is all about whether there's a failure to inform and consult. So employers should be ordered or could be ordered to pay a protective award of up to 112.5 days, actually, uncapped per affected employee because of that increase. And remember, the code doesn't ban the practice of dismissal and re-engagement, so it's not outlawed it. It just encourages employers to have this proper dialogue and consultation, explore options, make it a last resort rather than a first resort. And the code is also engaged as soon as an employer raises the prospect of a dismissal and re-engagement on revised terms as a consequence of employees not accepting any proposals. And also remember, if this is going to affect 20 or more people, then you've got collective redundancy obligations that will apply as well. So if the numbers are 20 or above, you've got additional obligations too. So what changed on the 20th of January was the ability to apply a 25% uplift if you'd unreasonably failed to comply with the code. Okay, then coming in soon, we have neonatal care leave and pay. So this provides for a statutory right of up to 12 weeks paid neonatal care leave for eligible employed parents who have a newborn baby admitted for neonatal care. And this is a right in addition to the other leave entitlements, such as maternity or paternity and so on. So this 2023 Act is very much an enabling act, with much of the detail coming out in regulation. And on the 20th of January, the government published the draft substantive implementing regulations that means it comes into force on the 6th of April. And it basically allows parents to spend, more time with their babies who are having this very specialised care without the worry of having to take unpaid leave or even trying to return to work. It's also going to be a day one right. So that means employed parents of children born on or after the 6th of April this year will be entitled to neonatal leave from the first day they start a job. And it can be taken after maternity or paternity leave. But anyway, there's lots of rules. That it's very prescriptive. It also says that eligible parents can take up to 12 weeks of leave. And and a parent will be entitled to 1 week's leave for every week their child spends in neonatal care, basically capped at that maximum of 12 weeks. So I think I've set out very briefly on the next slide what this is all about. In addition, let's talk about the pay before I go forwards, actually. In addition to the leave, there are rights to pay. And it says employees will have to have at least 26 weeks service to be entitled to be paid for their neonatal care leave at the prescribed rate, which is the same rate that we pay maternity and paternity and adoption and so on. People can come back to the same job. They shouldn't be dismissed or suffer a detriment if they've taken this leave. They shouldn't lose out, you know, in any way or be treated in any way less favourably because they've taken it. And I've seen lots of big employers actually introducing, you know, a raft of family-friendly policies. In fact, Tesco's recently announced they were including paid kinship leave for employees that are responsible for caring for any relatives' children. So a new one, there's no legislation for that. So yeah, I think more and more employers are embracing, you know, the fact that people have things that go on in their lives that do affect them at work, and we may as well account for, you know, how we'll deal with them when they happen. But paid kinship was a new one on me. So I've put on this slide, you know, very briefly what this new legislation says. And the last I read, it was estimated that some 60,000 new parents will benefit from this legislation. And in addition to the final regulations, the Department for Business and Trade is also going to issue practical guidance for employers and employees, which will cover the topics of, you know, making payroll adjustments, handling leave requests, understanding the protection available to employees, and so on and so forth. So definitely worth looking at the regulations, setting out how the leave will work in practice, putting together your policies, thinking about any training and awareness you need for managers or HR staff, you know, just so people understand what the new rights are and how to handle any requests. So that one's coming in April. Then we've got the fact that employers, and I'm sure many of you are aware of this already, there's a number of workforce crimes on the statute books already, you know, failing to lodge an HR1 form in a collective redundancy, for example. That's where you have to complete this form if you're making or likely to make 20 or more people redundant. You have to fill out the HR1 form and submit it on the government website. If you breach health and safety legislation, that's another workforce crime. But employers will have a new one to add to their list, which is the failure to prevent fraud. And very briefly, you know, this applies to large employers, which means employers have to meet 2 or more of the requirements. So they have to have either a turnover of over 36 million and or total assets of over 18 million and or over 250 employees. So they have to meet 2 or more of those requirements. So again, we need to look at our employment contracts, look at our policies, make sure they cover the prevention of fraud and the fact that a failure to comply with the employer's requirements in this regard would be treated as a disciplinary matter leading to a gross misconduct dismissal. I've seen quite a few employers also carry out pretty comprehensive fraud risk assessments and monitor and review any fraud detection and preventative procedures, as well as you know, training and educating their employees. So that relates to fraud. I want to next talk to you about the Employment Rights Bill. So I touched on that earlier. This is currently working its way through the parliamentary process. Once its provisions reach the formal legal stages, they will enter the timetable. The bill includes many of the measures set out in that Labour Party's plan to make work pay that I spoke to you about shortly. And it was published, as I said, last October. And it's very pro-business, pro-worker, apparently. And it's going to lead, to be quite honest, to the most radical changes I think we've seen in maybe 50 years. There's approximately 60 now employment law pledges, and the bill is going to take a while to go through consultation with trade unions and employee reps, as well as the parliamentary process. So the good news is that it's going to take a while for most of it to come in, won't be taking effect until 2026, which gives employers plenty of time to look at their policies, think about compliance, what changes they might need to make, if any, in order to be compliant, and maybe even have a best practice approach. We also saw the publishing of next steps to make work pay, which outlined the time frame for the reforms that have been set out in the bill, as well as a few additional matters that have been raised, which again, I'll talk to you about those as well. So let's have a look at some of these. I'm not going to take you to all of them, but I'm going to take you to probably the most common or far-reaching. The first one relates to sick pay. So the 2024-25 rate of SSP was £116.75 per week for up to 28 weeks. And that will go up soon in April, as I said earlier. To gain access to payments, an individual must be classed as an employee and must have done some work for their employer, and they must earn at least the lower earnings limit, which is currently £123 per week. They also must have been sick for at least 4 consecutive days, because I'm sure many of you will be aware, SSP is not payable in the first 3 days of sickness, which are called qualifying days or waiting days. So what's the change? Well, the new proposed change means that all workers, including those who earn below that £123 per week, will now be entitled to statutory sick pay from day 1 of their sickness absence. So not only is the lower earnings limit going to be removed, the waiting days will be scrapped too. So this is regardless of length of service. So that's the first change that we might see with the new bill. Then we've got bereavement and family leave. So the bill is committed to establish rights to statutory bereavement, paternity and parental leave from someone's first day of employment. So we've got the existing statutory right to parental bereavement leave. So this is already our legislation of up to 2 weeks paid leave following the death of a child under 18 or a stillbirth. And that's going to be extended to become a day 1 statutory entitlement to protected time off to allow an employee to essentially grieve. And the regulations will set out who will be entitled to take bereavement leave by reference to the employment relationship to the deceased, as well as how leave can be taken. And it's understood that the length of the leave will be a minimum of 1 week, and it will be unpaid. It remains 2 weeks paid leave for a child, and the employee will be permitted to take the leave up to 56 days after the death of the deceased. And then we've got paternity leave and unpaid parental leave. So currently employees who wish to take statutory paternity leave must have worked for at least 26 weeks. And in the case of unpaid parental leave, they must have worked for a year. So paternity is 26 weeks service, parental leave is a year. And the bill will remove those service requirements and make these day 1 rights too, subject to the employee giving the required notice. So employees will therefore be able to give notice of their intention to take that kind of leave from day 1 of their employment. So what does this mean for us? Well, the government has suggested that nearly 2 million people in employment are affected by grief per year, and that they anticipate tens of thousands of fathers and partners will be brought into the scope of statutory paternity leave following the changes. And it's excuse me, it's therefore very likely that these changes will affect most employers going forward. I've seen many employers offer discretionary or even contractual bereavement leave and unpaid parental leave as well. But, you know, it may be that you have to review your policies and procedures to be prepared for any of these up and coming changes. So the Employment Rights Bill would be the first phase of implementing these. And as I said, we probably won't see it until 2026 now. Okay, next, the bill also provides that regulations can be introduced to provide enhanced protection from dismissal during pregnancy and following the return from maternity, adoption or shared parental leave. And it will also apply to certain other returners from other forms of leave not currently in force. So, you know, neonatal leave, for example, will be added to this. And it's already unlawful to dismiss someone because of their maternity. For example, you know, if we dismiss someone because they're on maternity leave or a reason related to it, that is an automatic unfair dismissal. And what this is going to do essentially is expand that even further. So I suggest that even if there is a non-discriminatory and fair reason for dismissal, it could still be unlawful, subject to what we assume will be some exceptions and common sense. And I would stress those exceptions must be made to permit dismissal for things like gross misconduct or redundancy where the whole business is closing down. Obviously, this is all still to be determined, but we don't know exactly the scope of the proposal of this protection. So it's all very well saying you can't dismiss, but there will be circumstances where there is no alternative. So we don't know the scope of the proposal yet, nor do we know exactly how long the protection will apply following the return from those various forms of family leave, although the suggestion does seem to be it's likely to be protection for around 6 months after someone returns, which is the same as those priority rights for suitable alternative vacancies in redundancy situations that I was just telling you about. So basically, this protection from dismissal is likely to last for up to 18 months if you went from the start of maternity leave, for example, to 6 months after returning from a year's maternity leave. So what does this mean for you? Well, at this stage, not very much. It's simply a case of waiting for the publication of the final regulations to understand the full extent of the proposal. But it does seem likely that the intention is to restrict the circumstances in which you might dismiss a pregnant employee or a family leave returner fairly. So we really need to wait for more information. But the concept is to give more protection from unfair dismissal. Then flexible working. So we saw changes last year to flexible working, and I've explained what changed. Staff can request, as you know, can request flexible working from a day one right, things like compressed hours or working from home or reduced hours. But there's no duty on the employer to agree. There's just a limited list of reasons that they can be turned down, and an employee can make 2 applications per year and so on. So I've explained that to you already. More changes proposed in the bill for this year / next year. So the bill plans to strengthen that new legislation even further, where employers may only refuse a request for flexible working where it is deemed as unreasonable to grant the request. So this seeks almost to create a presumption that flexible working requests are approved unless it's not feasible on business grounds to agree to it. So any refusal of a flexible working request has to be given in writing and has to be reasonable. At the moment, excuse me. Excuse me. And as we know, you've got those 8 business reasons that I put up on the previous slide in order to turn someone down. But under the new changes, the employer will now have to clarify the reason that they're refusing, firstly. So A, the reason for the refusal for the flexible working application, and B, explain why their refusal on such ground or grounds is reasonable. So it's an extension again to under what circumstances we might turn someone down. And as I said before, breaching the flexible working regulations isn't massively expensive. It's up to 8 weeks' pay. The issue is where it's connected to some discrimination, to a maternity returner, to somebody needing flexible working in relation to a disability, for example. So it's not just the breach of the regulations we need to be mindful of, it's whether that breach is connected to a protected characteristic under the Equality Act. Then we've also got a mention of 0 hours contracts, which periodically comes up with little bits of legislation. The current position on 0 hours contracts is that, and I hope you're all familiar with this concept, unlike a traditional contract of employment, a 0 hours contract offers no guarantee of work, basically. There are no hours guaranteed. It is simply an agreement between the employer and the individual where that person might be asked to perform work, but with no minimum set contracted hours. And there's advantages for employees on 0 hours contracts. You know, it's a very flexible schedule. Often it's a way into permanent employment. It gives people the freedom to have multiple jobs or temporary income, or even just gain work experience. So they're not necessarily a bad thing, but there are potential downsides too. Unpredictable working hours, unpredictable income. And there've been no statutory restrictions on this type of contract. So employers have always had the freedom to use them and offer workers varied working hours on a week-by-week basis. So the proposed change under the bill, excuse me, is that employers will have to offer workers on 0 hours contracts and workers with a low number of guaranteed hours who regularly work those hours. They will have to be offered the ability to move to guaranteed hours contracts, which reflect the hours that they regularly have worked over a 12-week reference period. So if more hours become regular over time, subsequent reference review periods will provide workers with the opportunity to reflect that into their contracts. So it's going to be really interesting if that comes in and how it works, because the more regular the hours, the more the ability to move to those being your guaranteed hours in a contract comes into play. And if there'll also be actually another right, which is the right to reasonable notice of a shift for workers and the duty to compensate them for cancelling shifts without reasonable notice. So another potential change. So because 0 hours contracts are often deemed, you know, exploitative, and employers it's very much one-sided, these will change some of the rights for people who have a 0 hours contract. So it will offer the workers on 0 hours contracts and workers with low number of guaranteed hours who regularly work more than those hours the ability to move that to guaranteed work hours. And as I said, you'll be looking at that 12-week reference period. So again, if you have employees in that 0 hours category, this might be a fairly substantial change. Collective redundancy is next. As I said earlier, a collective redundancy is where you are potentially making 20 or more people redundant in a 90-day period at a single establishment. So there's 3 reasons that the collective consultation legislation comes into play. 20 or more people within a 90-day period at a single establishment. So if you've made 12 people redundant, 25 days ago, and you're now, going to make another 12 people redundant, that's more than 20 within a 90-day period. So you can't just look at each redundancy scenario. And as I said before, the protective award is up to 90 days pay per employee. So that's the current position as to what a collective redundancy is. And this is all about consultation. If you have a trade union, you must consult with the union. If you don't have a trade union, you must enable your employees to vote an employee representative group, and then you must consult with that group as if they were a trade union. So what's going to change? Well, the bill will remove the reference to the single establishment part of that three-tiered definition that I just gave you. And it will ensure that when an employer is proposing on making 20 or more redundancies within a 90-day period, it's the number of redundancies across the whole organisation, all sites or all offices, that would trigger collective consultation. And that includes notification to the Secretary of State on that HR1 form I mentioned to you, which is a legal obligation to complete. So the single establishment point goes. So have you made 20 or more people redundant anywhere in your organisation within 90 days? If so, collective consultation will apply. So as a result, it's highly likely that more and more collective consultation, more collective redundancies will take place. So employers will need to consider the structure of their redundancy process in order to adjust timelines, because it takes longer to do that. Having to help your employees elect representatives from different parts of a business, bring them together, get them understanding what their obligations are as representatives, all takes an amount of time that you would have to add to your redundancy timeline. It's also proposed to raise the protective award. So the protective award is where an employer has failed to comply with their obligations, and often this is failures to consult properly. If an employer fails to comply with collective redundancies, then the protective award is 90 days actual pay to all employees affected. And another part of the bill is to double that to 180 days actual pay. So a really expensive a penalty for not complying. And it's also in the bill to make the remedy of interim relief available to workers with protective award claims. So I wouldn't expect many of you to have heard of this concept of interim relief, because it only applies to a limited number of cases, notably trade union dismissals and whistleblowing dismissals. So if someone is dismissed for being a trade union member or for whistleblowing, they can apply for interim relief, but you have to apply really quickly to an employment tribunal. And interim relief is basically where the employer is told you have to take that person back on until their case is heard, or you have to pay them as if you were employing them until their case is heard. So either reinstatement or compensation in those two circumstances. And any sums paid out are not recoverable, even if the employee eventually loses their case. So it's a tricky situation. It doesn't happen that often because there's not loads of trade union dismissals, but you do see it happen sometimes in whistleblowing dismissals. So what the legislation will say is this will also apply to workers who are dismissed in collective consultation redundancies. So they'll be able to make interim relief requests too. So let's wait and see whether that one makes it through. But it's not an easy thing to have to deal with, and it's potentially quite expensive for employers, especially even if the employee loses, there's no recovery back. Okay, back to the fire and rehire, or dismissal and re-engagement, to give its proper longer name. I've explained to you the current situation with this. I've told you about the code of practice. I've told you about the increase of 25% on the protective award. But there's another proposed change that's coming in, and this change will clamp down even further on this concept, and says in the bill, it says it will only be permissible where corporate restructuring requires a practice as there is no alternative option. So basically, the government is trying to cut down and stop this practice at all. So notably, the bill will ensure, if it's passed in the form it currently is, that it will become automatically unfair to dismiss an employee if the principal reason is that they rejected the proposal to have their terms and conditions of employment varied. Similarly, it will be an automatic unfair dismissal if the employer dismisses the employee and then rehires the employee or recruits another individual under new terms of employment with substantially the same role and duties. So 2 new concepts to add to the unfair dismissal list. Currently, unfair dismissals, what makes an automatically unfair dismissal is where somebody doesn't have to have minimum service to bring an unfair dismissal claim. So if you're dismissed for discrimination or dismissed for taking parental leave, it's classed as automatically unfair. No defence either. And so this would add 2 more concepts to that automatically unfair list. So if someone rejects a proposal to vary their terms and conditions, automatically unfair potentially, or if someone else is hired or they are offered alternative employment, which is for substantially the same job. Okay. And remember that the bill says firing and rehiring will only be permissible where corporate restructuring requires a practice because there is no alternative option. Okay, so I think we just need to watch out for this one because it's a very common practice. You see it all the time. And I think that all of these changes are steering employers into, not having this as a common practice. And there was a consultation that opened on this. It closed on the 2nd of December, and we're yet to hear the outcome. But imposing contractual variations becomes far riskier. So I actually think before this does become legislation, better to audit your terms and conditions now and ensure that you've got good variation clauses already built in. So do you have the right to make changes already in some form or another? If not, should you be building those kind of clauses into contracts? So yeah, I think we just need to bear in mind that the intention is really clear that this practice is not one that the government's keen for employers to continue to carry out. So on that note, I've mentioned minimum service a few times. So please answer this question for me. How long do you need to be employed in order to bring a claim of unfair dismissal? Just a standard claim of unfair dismissal to an employment tribunal. So how long do you need to have worked to bring a claim of unfair dismissal to an employment tribunal? Not the automatic, which I've just mentioned, because you don't need minimum service, but what's the standard unfair dismissal? So I'll let you choose. I think I've given you 5 options. So here we go. 17% of you think normal unfair dismissal, there is still no minimum service. 9% think you need 6 months. 31% think you have to be out of your probationary period to have the right to bring an unfair dismissal claim. 6% went with 1 year, and 37% went with 2 years. So quite a nice spread of answers there. The majority are in fact right. So the 37% of you that said 2 years are correct. You need 2 years continuous service to bring a standard unfair dismissal claim. But it's interesting to see such a variety of other answers as well. As I said, if it's an automatic unfair dismissal, then there is no minimum service required. So discrimination-based dismissals, I'm dismissed because I'm a woman, I'm dismissed because I'm disabled, that you don't need any minimum service for that. But for a normal unfair dismissal, not connected to discrimination, not an automatic unfair dismissal, it is 2 years service. However, as I said, there are examples of where there is no, it's automatically unfair. And as I also mentioned to you, the government is talking about adding to that list of all automatic unfair dismissals. But at the moment, it's 2 years. And here's my however. So the new government is also very much about day one rights. As you've probably heard me saying, you know, that change to paternity, no longer 26-week service, it will be a day one right. Change to parental leave, no longer 1 year's service, it becomes a day one right. And the government is all about day one rights, providing individual rights for workers as soon as they join a new employer. And I think this change to have all unfair dismissals as a day one right was a real headline grabbing bit of this legislation. So the proposed change is that the bill will remove the 2-year qualifying period for an ordinary unfair dismissal, so employees can bring a claim to a tribunal from day one. It will also have a new provision to prevent those who have not yet started work from claiming unfair dismissal. To prevent those who have not yet started work from claiming unfair dismissal to other than where it is for one of those automatic unfair dismissal reasons. The right will, however, be subject to an exception, which is where the dismissal is for a certain reason made during the initial period of employment, which is essentially a probationary period. And although that is yet to be confirmed as to what that duration would be, I would say it's likely to be 6 or 9 months, probably. That will be referred to as the initial period of employment. So this is big news. Unfair dismissal from day one, other than, you know, whatever rules we might see about that initial period of employment. So it's not clear how that period will operate. Although I think one likely outcome is that employers will have to follow a set process. And I'm sure this will be contained in a code of practice at some point or another, as to how to lawfully dismiss an employee during that probationary period. So I'm sure that there will be some prescriptive or significant steps, you know, what meetings might have to take place, what information might need to be provided to the individual about why they're being dismissed, whether you'll need to give written reasons for termination of employment. I mean, at the moment, our legislation says you're not entitled to a reason for your dismissal if you have less than 2 years service. Someone can simply walk up to someone who's been employed for 18 months and say, we don't need you anymore, I'm paying your notice in lieu, you can leave in the next 5 minutes. No reason required, pay in lieu of notice, off you go. Of course, you'd be a very brave employer to do that, but you know, the law allows you to not be required to give a reason for termination if someone has less than 2 years service. So quite a lot of reform in this area. Again, these changes aren't likely to come into effect any sooner than 2026. And I believe with this one in particular, the government said it wouldn't come in until at least the autumn of 2026. We've got this whole, you know, probationary period piece to understand, and for employers to understand what steps they need to take. Talking about dismissals, fairness and procedures, another case that I should have mentioned at the beginning that really stuck in my mind was veil, curtains and blinds. An unfair dismissal case, I think it was Jones, and veil, curtains and blinds. And this was an employee attempting to forward a complaint email from a customer to one of his colleagues. And they accidentally clicked reply and sent the message they meant to send to their colleague back to the customer. Isn't this everybody's worst nightmare? So they clicked reply and sent this message or words to this effect. It said something like, can you deal with this? This client's a complete, I think it was it wasn't a twit, but it was words to that effect. So actually, it doesn't matter if you can't help them, or words to that effect. So can you deal with this? The customer is a complete, you know, rude word. So it doesn't matter if you can't help them. So the customer receives this email and complains, and they threaten to go to the press. And the employee is dismissed for doing this, is dismissed for sending that message to the customer. And the customer was notified of the dismissal of that employee as well. So this individual brings an unfair dismissal claim and says, I didn't do it on purpose. You know, it was an accident. I should not have been dismissed. And upholding their unfair dismissal claim, so they won, the tribunal really criticised the fact that neither the customer nor the employee were interviewed about what had happened and how they felt about it. The disciplinary procedure and the dismissal were basically a sham, and it was all designed to placate the customer. And the case really undermined that disciplinary procedures have to be followed. You know, it talks about investigations, it talks about meetings, it talks about understanding reasons and mitigation for and taking into account good service or, you know, long, clean employment. And the case really underlines that disciplinary procedures should never have a predetermined outcome either, and that thorough and fair investigations need to take place, even if it's serious misconduct. You know, predetermining an outcome, as was found to be the case here, is pretty much going to defeat every fair dismissal. There's another case that sticks in my mind, which was Perkins and the NHS Healthcare Trust. And this was where Perkins was an FD in this organisation, a finance director, and they were dismissed. And how they discovered it was predetermined was that there was a request for a data subject access request for all emails that were about this individual in relation to these issues. The details don't really matter. And on one of the emails that was discovered and disclosed, it was an email from this person's line manager, the CEO, to the HR director that said, basically, we've got to get rid of Perkins. I don't want them to work here anymore. How do I do that? Words to that effect. So where there is a predetermination to an outcome, you know, customer already promised that we'll dismiss someone or we'll deal with this in the most serious way possible, it's going to potentially tip a fair dismissal into an unfair. Anyway, it just made me think of it quickly while I was talking to you about that. So this is a quick summary on this slide of what the changes to this might be. So employees will be able to claim ordinary unfair dismissal from day one of employment. So you'd have to have a fair reason, act reasonably, and follow a fair process in every case. And remember, there's only 5 potentially fair reasons to dismiss someone now. You can have a modified approach during that initial period of employment, which for many will be the probationary period. And that the modified approach will not apply to dismissals where notice expires more than 3 months after the end of that essentially probationary period, whether it's redundancy or for some other substantial reason which did not relate to the employee. So what to do? Well, I think careful recruitment, careful referencing, you know, minimize the risk of a bad hire in whatever way you can is going to become really important. Diarising that IPE, that initial period of employment, deciding whether you're going to mirror your probationary periods with whatever that is, you know, making sure that you've got notice dates when onboarding and remembering that could be different to contractual dates. I think actively managing people's performance and conduct during that initial period, making sure you educate and train managers of others as to what they need to do. I think aligning probationary periods with the IPE would be a sensible thing to do, just makes life a little bit easier. Obviously, understanding exactly what the modified approach requires. So what steps would you need to take to dismiss someone during that initial period? So I think it will become very important to, you know, manage people really fairly from day one onwards and make the best decisions you can when recruiting as well. Then we've got gender equality reporting. So we're still in, you know, what the bill says that they plan to do. So the current position, then, just a quick reminder, any employer with 250 or more employees, 150 in Scotland, by the way, on a specific date each year, which is known as the snapshot date, must report their gender pay gap data. And if you have to report it, you must report it and publish it in your gender pay gap information within a year of that snapshot date. In Scotland, the employer must publish information on the percentage difference amongst its employees between male average hourly pay, excluding overtime, and women's average hourly pay, excluding overtime. Snapshot dates 31st of March for public authority employers and the 5th of April for everybody else. And there's lots of rules on this already. So what's the change? Well, the bill includes a new provision which will require organisations, still with 250 or more employees, to publish an equality action plan every 12 months. So at the moment, you can publish your data and say nothing. The change will be that you publish your data and then you publish an equality action plan. And that plan should include steps that the employer is going to take to advance equality and opportunity between male and female employees, including how the employer aims to address the gender pay gap that they have, if they have one, and how the employer is supporting employees, by removing that gender pay gap. So if you already fall within that category, if you're already having to publish your gender pay gap information, it's a good time to start thinking about what your equality action plan might be. So that's for larger employers only. Now, we know that from the 26th of October last year, there is this duty to prevent sexual harassment and take reasonable steps to make sure that you've done that. Good anti-sexual harassment policies, good training, good education, making sure that we understand where the risks are and so on. And as I said, if an employer fails to take those reasonable steps and there is a claim brought and that claimant is successful, then the increase is up to 25% more in an award. And the EHRC can investigate and take enforcement action. So that's what we know we've got already, because that came in October. Under the bill, there's more change envisaged. And this is that employers shouldn't just take reasonable steps. So the law currently says you should take reasonable steps to, comply with this duty and eliminate sexual harassment. Under the bill, it says employers should take all reasonable steps. So insert the word all, which means every possible step to prevent sexual harassment. We also think the bill is going to set out, or the eventual regulations or act will set out what those steps are going to be. At the moment, we have that non-statutory guidance, which I told you about, which actually is really, really good. If you haven't had a look at it, it's very helpful. But what this says is that there will be statutory steps. There will be obligations on what you should do. And even though they're likely to vary in some respect from employer to employer, I think it's definitely going to talk about risk assessments. Where is sexual harassment likely? I worked with a client recently who did a risk assessment for their Christmas party, because that's a risk area. Stick people with alcohol in a social environment, and sometimes things happen. So risk assessments, proper plans, good policy, good training, how to report sexual harassment, how to handle complaints. I mean, I've listed 5 or 6 there already, things that are likely to be minimum requirements. So practical steps, I think, is what this is all about. Thinking about each of those areas and how you can tackle ensuring that you're complying with this legislation that we already have, and whatever changes may come from inserting the word all into the reasonable steps that you must take. The bill actually, and again, this isn't going to come into effect until 2026, but we've already got this legislation, so it's things we should be thinking about now anyway. The bill also extends protection to those who are whistleblowers on sexual harassment. So those who choose to use whistleblowing legislation to raise concerns rather than bringing personal grievances. And it also includes protection from harassment by third parties like clients and customers. It is worth noting that the bill actually will make employers liable for third-party harassment as well. So instead of it just being guidance that we need to protect people from third-party harassment, another change proposed by the bill is that employers will be liable when it takes place. And that won't be just for sexual harassment either. The bill plans to extend that to all the protected characteristics: race, religion, gender, disability, all 9 protected characteristics. But obviously, to win, the employee will also have to show that their employer failed to take all reasonable steps to prevent that third-party harassment, which is tricky for employers that work with the general public. But sometimes, there are harassment policies. It's not unusual to see signs up that we won't, accept any harassment towards our employees, or, signs or those kind of things. Even sending suppliers policies that you must comply with if you're going to work with us isn't that unusual anymore. So definitely thinking about risk areas and things that you could do to minimise those risks is an important thing to do from this point onwards. And I think what we'll do is stop here before we go on to talk about the last few parts of the bill. So I think it's 7. So let's be generous and give you 7 minutes this time instead of 5, if that's okay. So if you come back, please, at 11 o'clock. We'll do the last bits of the bill, and then we'll get on to the last section of the last hour of our time together. So I'll see you back here at 11, please. Thank you. Hi, and welcome back. I've just noticed I've got a couple of questions in the Q&A. So one of them is for neonatal pay. Neonatal pay. Is it 26 weeks by the 14th week before the expected week of confinement? Expected week of confinement is a very modern term for the week the baby is due. And the answer is, for neonatal pay to be payable, the employee must have been continuously employed for 26 weeks at the point they want to take the neonatal leave, and they've got to earn above the lower earnings limit, the £123. So it's not 26 weeks. Well, my understanding, probably should double check this to be 100% sure, but I understand it's 26 weeks continuous service at the point you want to take the leave, not the expected week of confinement. But just to be 100% sure, I can always double check that if we know who's sent that question in and just reply to you. And then I've got a question about firing and rehiring, because I have mentioned it several times. So how will the new firing and rehiring rules and automatic unfair dismissal rules affect an employer who decides to outsource roles and make staff redundant as a result? And that's a really interesting question, because the firing and rehiring is all about normally saying, I need you to change what you do, or I need you to change what hours you work, or I need to change what I'm going to pay you, or I'm going to change some sort of benefit. So normally it's, I try and negotiate this with you and agree it with you. If I haven't, I do have the ultimate option of saying, well, here's your notice, you're going to be leaving. And then in the same envelope, think of it in that way, here is also a letter saying, I want you to carry on. But if you carry on with continuous service, it's on the new terms, using that example that I've been trying to negotiate with you. So when you relate it to how does it have an impact on outsourcing roles, it probably won't, because outsourcing roles falls within the TUPE remit that we were talking about very briefly earlier when I told you about the changes to the TUPE rules. So when you outsource roles, people have the right to be outsourced with those roles too. So if a part of your business is taken on by a new organisation, those people employed in that part of the business would move to that new employer. So that's the TUPE protection. Good. Okay, let's carry on. Thank you for that. So we're about to talk about menopause action plans. So we've got increased awareness, which has been the case for some years now, about the menopause and its impact on people. And it's led to significant rise as well in the number of tribunal cases which cite the menopause as reasons for less favourable treatment. And we've seen successful menopause cases be brought as sex discrimination cases, as age discrimination cases, and as disability discrimination cases. So as well as presenting litigation risk, the menopause has also become an area of reputational issue for employers as well. Who wants one of those negative cases to follow them around? So following steps taken by the previous government to improve menopause support in the workplace, the bill will introduce or has introduced a requirement for employers with at least 250 employees to produce and publish a menopause action plan. And it is said that this could also be extended to other matters like menstrual health problems and disorders too. So we again expect the government to publish regulations in due course prescribing the content of such action plans, how frequently they should be published, whether there's a requirement for senior leadership approval, and so on and so forth. Again, it's not going to come into force until at least 2026. So similar to the pay gap action plan, we're likely to see this menopause action plan too. And I work with lots of employers and see lots of great policies supporting people that might experience difficulty during the menopause and at work. So that's another action plan that's proposed. Good. So we've talked already about the action plan that the gender pay gap, the action plan that will result from gender pay gaps. And really compliance has been pretty patchy and progress not actually too brilliant often where there has been a gender pay gap identified. So again, the aim of the legislation is really to focus on what we should be doing about the gender pay gap. There's also talk about reducing that criteria from employers with 250 or more employees to a lesser number. So again, we need to keep an eye on those to see whether maybe you weren't caught before, but you will be caught in the future. We also see some trade union reforms. So I mentioned one to you already about minimum service levels. There's quite a few reforms contained in the Employment Rights Bill that are expected to actually come into force in later on in 2025. So I'm not going to go through them in masses of detail because they're very specific, but very briefly, there is a requirement for workers to be given a written statement telling them that they have the right to join a union. So that would be new, that everybody would be told you can join a union. Heightened protection for workers engaged in industrial action, so protection for those that are either on strike or taking action short of a strike. Reduced thresholds for industrial action ballots, making it easier to get a vote in favour. I believe it would change to there just needs to be a majority of people that vote rather than any minimum numbers that must vote. Provisions for access agreements, so allowing union officials, and these are people employed by the union, not by the employer, so allowing access agreements so those union officials can access the workplace and meet representatives or get involved in recruitment, or organising workers, or facilitating collective bargaining. And then the information and turnout requirement for ballots is going to be simplified to make a ballot easier to manage. And the right to complain that there has been a failure to provide access to facilities, things like, a meeting room or, photocopying facilities, those kind of things. And also widening of the power for the Secretary of State to make regulations prohibiting lists for discriminating against workers on the grounds of trade union or trade union related activities. So simplifying the thresholds for trade union recognition will make it much easier for trade unions to achieve recognition. So at the moment, a trade union needs to demonstrate that there is already 10% of those employees in that employed by that employer are already trade union members, but they're proposing to reduce that down to as low as 2%, and a number of other changes. So lots of changes, pro-union membership, making industrial action ballots and recognition for new trade unions in new workplaces much easier. Lots of change to be supportive in those areas. So there's a few other areas affected. I've tried to sort of pick out the main ones for you. They're talking about in the bill about removing discriminatory age bands to ensure every adult worker benefits from a genuine living wage, irrespective of their age. We're going to talk about national minimum wage in a minute. Supporting workers with a terminal illness through the Dying to Work Charter, modelising health and safety guidance, and it talks about the introduction of the right to switch off to help prevent employees that are harassed by their employer outside of normal working hours. On that last point, actually, the right to switch off, the government also made a pledge to bring in the right to switch off as part of their Make Work Pay paper, and said that they would introduce a code of practice. We're going to have lots of codes or lots more codes of practice. But the pledge didn't actually consider how this would work in practice. So, of course, that's where these codes are really important. Would it be a standalone claim, that you failed to comply with the right to switch off, or will it be more of an aggregating factor to consider, in terms of compensation for unfair dismissal or constructive unfair dismissal? So hopefully we'll receive more information as this year progresses. There's also, actually, should mention that this concept to simplify worker status as well wasn't part of the bill, but it was in the paper. And it talked about, instead of having 3 status options, employed, worker, self-employed, having 2 options, self-employed or worker. So, we'll see. So that, basically workers and employed come together, and then we have self-employed. So it could be changed there as well. So how will these changes be enforced? Well, the government intends to establish something called the Fair Work Agency, and that will have new powers to enforce things like holiday pay and statutory sick pay and parental rights and minimum wage and so on. And that new enforcement body will be able to enforce with penalties and fines on employers who breach employment rights. And in practice, enforcement officers likely to be able to access a workplace, conduct a workplace inspection, initiate civil proceedings, and prosecute violators, and maybe even seize, necessary items when needed as part of those investigations. And so it's planned it will consolidate lots of other existing regulatory bodies that we already have, like the Gang Masters and Labour Abuse Authority, and we've got the National Minimum Wage Unit and so on. So kind of do away with those and create this new Fair Work Agency. Separate to the bill, but also potentially new, is the Paternity Leave Bereavement Act, which was passed after being rushed through Parliament in the final hours before the election campaign started. And this isn't connected, as I said, to the Employment Rights Bill, but it is all about providing support for bereaved fathers whose wife or partner or birthing partner dies. And we've got no date yet for its implementation. But before the Act was introduced, fathers and partners needed to complete at least 26 weeks of continuous service to get paternity leave. We know that that's changing. But obviously that's different for, it's the opposite for wives and birthing partners who want maternity leave. So this Act will scrap the minimum service requirement for bereaved partners in cases where the mother of a newborn child has died. So employees won't need to complete 26 weeks of continuous service to qualify for leave. And bereaved parents of adopted children and children born through surrogacy arrangements will also have that same cover. So it will be a day one right for bereaved partners. So it's going to ensure that where both the mother and the child die, for example, bereaved partners will still be able to take leave despite the fact that the leave isn't taken to care for a child or support the mother. So there'll be some extension there as well. And it's also going to allow regulation which will permit a bereaved partner to keep in touch days whilst they're off as well, without bringing any period of leave to an end. So a few changes there for a rather sad and specific circumstance where we see the loss of the mother of a child. Okay, in May 2023, so I'm going back a bit further than normal, the UK government also announced that it was going to introduce a statutory limit of 3 months on non-compete clauses. I don't know if you remember us talking about this before. That was going to go into employment and worker contracts. And we've got tons of case law on, non-compete clauses that will stand up, and we've got tons of case law on ones that haven't. So our cases already tell us that non-compete clauses should not unreasonably restrict an employee's ability to work or to find suitable employment after they leave a current job. So in order for a non-compete clause to be enforceable, it should only cover a reasonable, temporal or geographical scope. It should be tailored to specific legitimate business interests, such as, confidential information or customer connections, customer details. It should also consider the seniority of the employee and the nature of their work. So the kind of blanket same non-compete for the, receptionist to the head of sales is highly unlikely to make it enforceable. And then lastly, and probably most importantly, any non-compete clause shouldn't unduly hinder an employee's ability to earn a living, or it shouldn't limit their career prospects. So we have that already. So those requirements sort of try to ensure that non-compete clauses are fair and proportionate and strike that balance between protecting the employer and the rights of the employee. And the non-compete clauses aren't the only type of restricted covenant that we can have. We can have non-solicitation, non-dealing. We can have, protecting sensitive information, confidentiality, and all those additional clauses. So consultation took place about this change, and it did confirm that the proposal to cap non-compete clauses in contracts at 3 months was the right decision. But, when is that going to happen? Well, the government has not given any dates. In fact, I think it last said this will be brought in when parliamentary time allows, which is a very broad statement. So it hasn't gone away, it just hasn't gone forward very far. So we continue to watch this space to see whether the 3-month restriction will become contractual. And then also separate to the bill that I was talking to you about, the government also proposes to introduce a separate bill on pay gap reporting and equal rights. But in this case, it's not gender based, it's about disability and race. So it's called the Equality, Race and Disability Bill, and it includes proposals published that talk about, you know, extending protection from differing rates of pay that relate to race and disability. So again, it's for employers with more than 250 staff. They will have to measure pay and report on those gaps. It will extend equal pay rights to protect workers suffering discrimination on the grounds of pay relating to race or disability. It's already unlawful to pay someone less than someone else because they are a different race or because they have a disability. So you would bring that as a claim under the Equality Act anyway. This is about reporting on that and ensuring, and then probably taking action with a workplace plan that we talked about earlier, referring to the menopause and to gender pay gaps as well. It also says that outsourcing services can no longer be used to avoid paying equal pay, and it will implement a regulatory and enforcement unit for equal pay. So let's wait and see whether we will see this extension on pay gap to not just be about gender, but also race and disability too. A question for you next. So are claims about bullying brought under the Equality Act of 2010? So is that the legislation where somebody would bring a complaint or a claim about bullying? So just a yes or no. Excuse me. Okay, if we've got selections in, let's see what the results are, please. Goodness, that is an even split. So 51% say yes, you bring your bullying claim in the Equality Act, and 49% no. Well, on this occasion, it's the 49% that are correct, because bullying is not mentioned in the Equality Act. In itself, bullying cannot be a claim to an employment tribunal, but it can lead to other legal issues. So, for example, severe bullying might be the reason that someone leaves their employment and brings a claim for constructive dismissal, but that's not an Equality Act claim. If the bullying is targeted and relates only to someone because of their protected characteristic, then the claim wouldn't be bullying, it would be discrimination. So if I think you've treated me in this awful fashion because I am, you know, disabled, then I would bring a disability discrimination claim. If I'm treated in this awful fashion, if I feel bullied in the way I'm treated at work, but it's not related to any protected characteristic, then I can't bring a claim under the Equality Act of 2010. So bullying itself is not against the law when it comes to the Equality Act, but harassment is. So if I'm treated that way because of a protected characteristic, it's not bullying, it's in fact harassment or discrimination. The reason I asked this question is just to talk to you about the next point, which is the Bullying and Respect at Work Bill, which is a private member's bill proposing legislation that would introduce for the first time a statutory definition for bullying and enable claims related to workplace bullying to be considered at an employment tribunal. And this is due to have its second reading in Parliament on the 20th of June. So we don't have a standalone claim. We do often have issues that lead people to bring constructive unfair dismissal complaints. And obviously you're very familiar with discrimination claims, but this would bring a new statutory protection for people that are bullied at work. Good. So that's 2025 done. Some of it we know is definitely happening. A lot of it is in that bill or other bills, and most of it won't come in until 2026. So next year we could see a substantial amount of change, as I've tried to indicate for you. So let's look quickly at the statutory calculations next. We don't have figures for them all yet, they just haven't been released, but what we have, I'm going to tell you about. So the whole family-friendly statutory payments for 2025, we've got the new rates. So this is statutory maternity pay, paternity pay, shared parental pay, adoption pay, bereavement pay, and the new statutory neonatal care pay. And they will all go from £184.03 to £187.18 on the 6th of April. We also have the new national minimum wage rates, which I've put on the slide there. And the government accepted the Low Pay Commission's recommendations. These will all apply from the 1st of April 2025. So I've set the new rates out. I don't need to read them to you. And they will, and in fact, from the 1st of April 25, an employee who is paid the national living wage and works around a 37.5-hour week would receive a salary of just below £24,000 if you work that out. And that's an increase of just over, I think, £1,500. So £24,000 or there or thereabouts will be the full-time national minimum annual wage. And Labour's plan to make work pay stated that they wish to ensure that the national minimum wage was a real living wage that people can live on. So they're expecting it to always be 2/3 of the median earnings and to have the highest kind of value that we've seen in the UK's minimum wage so far. So I think it's likely to continue to climb. I mean, there are, for non-compliance, there are hefty fines, which I'm sure you're familiar with already, and the whole naming and shaming of employers. So every year we get that list of employers that have failed to comply with their national minimum wage obligations. And also the government has said that the national minimum wage rate for the 18 to 20-year-olds will remain from this April. But to narrow the gap in the future, they are talking about having a single adult rate. So we'll see whether that changes as well. But for this year, the 18 to 20-year-old rate remains. The real living wage, so this is the Living Wage Foundation. They announced that the 2025 real living wage would increase by 5%. From £12 an hour to £12.60 outside of London and to £13.85 in London. So this is an increase of, I think it was 5.3%. So there's lots of employers that have signed up to this. This isn't a requirement. I think there were 15,000 last time. So lots of employers have signed up to this. And the real living wage kind of differs significantly from the national living wage, which is £11.44. Yeah, and the real living wage is £13.85 in London, so significantly different. We've also got this increase to employers' national insurance contributions. I'm sure you might be aware of this already. 6th of April, this change will rise from 13.8% to 15%. So that will be quite an expense. I know quite a few, again, of employers and clients that I know that may have paid bonuses in April are now going to pay bonuses in March because it will be at the lower rate. So things to think about. And then SSP is going to increase to 118.75. Statutory redundancy pay cap on a week's pay in 2024 was 700, and we don't know the 2025 rates yet, that they just haven't been announced. So I can't give you those. And the same for the unfair dismissal compensation awards. They haven't been announced yet either. Personally, I'll be a bit sad when we move away from 115 and 115 because it's nice and easy to remember. But there you go. That's the maximum you can win at an unfair dismissal complaint at the moment, or a week or 52 weeks gross pay, whichever is the lower of those two amounts. But again, we haven't got what the new rates are. We don't have the new rates for the Vento bans either. I've put up the current rates for you just as a reminder. As I mentioned earlier, these are payable in where there's a successful discrimination claim as part of injury to feelings awards, on top of any other payments made like loss of earnings. Good, so that's all I can tell you on the statutory calculations. So our last section is just to look at a few other interesting cases from last year and see what they can tell us. So I've picked out a handful for us to look at. So this, in this case, the Employment Tribunal found, and this could be one of those headline cases that I told you about at the beginning, you know, where the headline for this one would have been, the failure to say hello leads to unfair dismissal complaint. Because in this case, the Employment Tribunal found that a failure to say hello to a colleague had contributed to conduct that destroyed or seriously damaged the relationship of trust and confidence between employer and employee. And whilst the conduct by itself was not a fundamental breach of contract, it contributed to a breach which led to the employee's claim of constructive unfair dismissal. So this was a case where Ms. Hanson, the claimant, worked for this employer, and when they went into, there were a number of problems, and a new respondent took over. So a new company took them over, and they went into administration, and she went across under TUPE, which I mentioned to you earlier, protecting her employment. But just days after the takeover, a new manager, who was also the owner and director, decided to visit the office where she worked to meet the workforce. And at that time, he learned that she predominantly worked from home, and therefore decided in his mind that she did very little, relying rather heavily on her colleagues. And unfortunately, that impression was formed without having any discussion concerning her role, or having any real clear information about it at all. Anyway, he visited the office again, and the claimant was late in that day due to a pre-arranged medical appointment. Remember, there had been a TUPE transfer. When she eventually arrived, she said, you know, hello to this director. No answer. Said hello on another 3 occasions, but was actually ignored each time. So this led to the pair of them having a private discussion, during which she tried to explain that her lateness was quite legitimate. She wanted to show her appointment on her phone, but this new manager brushed her away, saying, I suggest if you don't want to be here, that you simply leave, which is a rather mean thing to say. She had 20 years service, so had been there for a very long time. And apparently responded with something like, the only way I'll ever leave is if you dismiss me or make me redundant, or something like that. Anyway, to cut a long story short, their relationship difficulties did not improve. And shortly after that meeting, this claimant found out that he had offered a pay rise to 2 of her colleagues and not to her. And that was her, you know, last straw. She left and claimed constructive unfair dismissal, and she won. So the tribunal found that she had been constructively dismissed. There was no reasonable and proper cause for this manager, this employer, to have ignored her despite her polite greetings on 3 or 4 times, to refuse to look at her phone or listen to her explanations for a genuine medical appointment, to tell her to leave if she didn't want to be there, to offer pay rises to her colleagues and not to her without good reason, and a few other matters. So that culminated together to be a constructive unfair dismissal. And I think the reason this is interesting is that it really is a good reminder that minor things can build. Not saying hello to someone might have a really big impact, but seem like a very small issue. And by the time you start to layer up a number of different matters, you can, as in this case, lead to someone getting home on a constructive unfair dismissal claim. This person felt they were treated disrespectfully, unfairly, and rudely in front of others and was upset about it. Probably, if some of that bullying legislation comes in, this might have been relevant to this case as well. So that's the first one. I'm always banging on about the importance of policy and procedure and process. It's so much of what I do and loads of other people when training line managers on how to manage people lawfully and effectively, and also conducting workplace investigations or appeals for employers. And this case with Apple Retail highlights, I think, the critical issues of great workplace investigations, top-notch disciplinary procedures, and adherence to company policies. And this was a case where Mr. Jeffries was employed by Apple from December until his dismissal. And events leading to his dismissal began some while back. He has a colleague who is of Chinese descent, and he made a remark to her along the lines of, well, as long as you lot don't spread another deadly disease in the world, obviously referencing the COVID-19 pandemic. Another colleague, so this was between Mr. Jeffries and this Chinese colleague of his, and another colleague overheard that conversation and lodged a complaint, and which prompted an investigation into a race-related matter. Anyway, to cut a long story short, he was found to have breached their policy when it came to equality, diversity, and inclusion, and he went through a disciplinary process for that. He was led to believe that it was Miss Liu who was aggrieved, this colleague, not the person who had overheard this matter, but he was never given any evidence of what the complaint was or who the complaint was from, so leaving him to believe it was her that had raised this issue. So he didn't understand the context of the complaint. And so when he brought his claim, the tribunal were really critical and criticised Apple's investigation and not giving sufficient context to allow him to properly defend himself. The investigation report also said that he breached the bullying and harassment policy, and there was nothing in that policy about, anything in particular like that. It was quite, the allegations that he was facing were quite vague in terms of how they related. Anyway, his colleague didn't even find his comments offensive, so she hadn't complained and wasn't offended. Anyway, the tribunal's decision was that they ruled in favour of him. He was dismissed for this race-related issue, and they said this dismissal was unfair. He'd shown clear remorse, and there was no reasonable basis for Apple to believe that he would go on to commit the same offence again. So it wasn't sufficiently serious to warrant dismissal, and he didn't pose a future risk because he was, greatly remorseful for it. He thought he had upset Miss Liu when in fact he hadn't. So the tribunal found that the investigation was inappropriate, had leading questions throughout it, had huge reliance on speculation and personal opinion rather than fact-finding, and they did not find that there was a zero tolerance policy that had been breached, because there was lots of examples of where people were doing or saying similar things. So it's back to that point. If you have a policy, you need to, comply with that policy. You need to respond fairly. I think the case really highlights evidence-based, proper statements, and also being transparent and open with an individual. You can't just say we have a zero tolerance policy, where in reality there's lots of examples going untouched, happening in a workplace that aren't dealt with. And also he was misled. he believed his colleague was offended and his colleague wasn't. Although, of course, you can be offended when you overhear something. So policy, procedure, good investigations, they win every time. So another question for you. In this, apologies, go back to the question. Sorry, my mouse is doing its own thing. If the signed contract says your place of work is in the office, can we simply require those that have been working from home to return to the office and work? So if the contract says your place of employment is in the office, can we simply require those that are working from home to return to the office and have that as their place of work? So yes or no? Let's see what you think. So this time we've got 60% of you saying yes. If the contract says place of work is the office, we can simply require people to come back to the office. And 40% of you said no. We've had some really split responses throughout this morning, actually. It's really interesting. So return to the office mandates, RTO mandates, increasingly in our headlines as businesses kind of grapple with the future of work. And we've seen lots of recent announcements, Amazon, Dell, JP Morgan, all saying, no, you've got to come back to the office. So lots of different opinions and views on this. And the COVID-19 pandemic led to a fundamental shift, obviously, in the way that business operated and mass adoption of remote working. But as the pandemic eased, employers began requiring employees to return to the office. And many employees just didn't want to do that. We've seen a lot of hybrid, a lot of split. You've got to be in for 2 days a week or 3 days a week. However, some employers are really now looking to bring employees back full time, citing concerns about low productivity and engagement and all those kind of things. So if you're going to, employers must provide employees and workers with a written statement that sets out the terms and conditions of employment and should always include a normal place of work. And in most cases, this written statement is a contract of employment. And if the employer states the normal place of work is the office, then they can require people to work in the office, because often employers haven't set out remote working conditions in the employment contract. You might have a separate policy on agile or home working or something like that, but it's very rarely in the contract. So if an employee who doesn't have the contractual right to work remotely unreasonably refuses that request from their employer to return to the office full time, they could face disciplinary measures for misconduct. They will potentially be in breach of their contract. Depending on the seriousness of that misconduct and the unreasonableness of the refusal, so there is a bit of a case-by-case review, an employer could dismiss an employee in such circumstances. Whether you would classify it as gross misconduct or whether you would classify it as progressive misconduct, where you give written warnings rather than just go straight to dismissal. But employers will need to consider any refusals to return to the office, as I said, on an individual basis. There is a risk in insisting employees return across the board without looking at personal circumstances, because that could be discriminatory. For example, some employees, may not be able to work in the office 5 days a week due to maybe underlying health conditions. Maybe that's something you didn't know about before. And if it's a disability, that's a protected characteristic. It could be that someone, has other reasons that they're unable to meet that request anymore. I've had a case recently where somebody had a child while they were remote working the last few years. Child has a number of disabilities. They have a live-in carer. They made their request in relation to caring for a disabled dependent. So employers, have to make reasonable adjustments where someone has a disability, where they have the disability. If there's substantial disadvantage, we can't discriminate against people. You know, we've got to look at those individual circumstances. And this is where your flexible working policy and procedure will come into play. And a lot of employers have said, if you can't return to the office, you need to make a flexible working request so we can consider, because remember, accepting a flexible working request is a permanent change unless you state otherwise. One point I always make to people when they deal with flexible working requests actually is to make it role specific. So if I can agree for you to work in this flexible way whilst you're employed in this role, then that's what's specified in our agreement. Should you, however, move to a different role, apply for a different part of our organisation, get promoted, then you will have to make another flexible working request, because our agreement is for you working in this role. So you can be relatively specific. And the reason I've mentioned all of that is that there's been this case where a claimant was employed as a senior manager, directly managed 4 employees, indirectly managed a further 10, made a request to work entirely from home, had already been working remotely since the start of the pandemic in early 2020. And the FCA has a split, hybrid working policy of 60-40, 60 remote, 40% in the office. And she wanted to be fully remote. Well, they rejected her request, gave lots of good reasons for it. She appealed, the appeal was refused, and off they went to the tribunal. And the tribunal found that the FCA had breached the statutory decision period time limit. So you've only got a limited amount of time to deal with a flexible working request. But that's only a 1 week's pay as compensation. And can be up to 8 weeks pay, but 1 week was deemed appropriate in these circumstances. They weren't that late. And the tribunal dismissed the claimant's claim that her flexible working request had been rejected on incorrect facts. They found that the claimant's line manager had actually carefully analysed the factors for refusing the request, and that it had not been based on incorrect facts. The FCA highlighted the importance of face-to-face interactions for managers when it comes to training and supervision and departmental needs and creating team spirit, and that she did manage directly and indirectly quite a large team. The tribunal found that there could be detriment for not meeting face-to-face, not welcoming new staff members, for all the ad hoc advice and support you get when you work together in an environment. So for those reasons, they found that, the FCA were fair in turning down this request. And they found that the decision was based on good facts, and the decision maker had genuinely considered the merits of the application and the specific reasons why it might have a detrimental impact, and tried to balance that against her good performance and great work while she had been remote. So really interesting case. If you struggled with asking people to return to work, this is a good case to read. So go have a look at it. The Supreme Court has released a long anticipated decision in this case, which is all about holiday and the gap of 3 months between underpayments and holiday pay. Because what has always been said is that if there's a 3 month gap between each period of holiday pay underpayment, then it breaks the chain of deductions. So then earlier underpayments become out of time. So this decision, however, has done something quite important, because it's put holiday pay back in the spotlight and potentially increased the financial exposure for employers who have not calculated holiday pay correctly, because it's now clear that a gap of 3 months between underpayments of holiday pay will not automatically break the chain of a series of deductions, which means people can claim more underpayment. So if you're we've had, you know, the requirement to pay holiday pay on normal earnings for a long time now. Many employees on regular, you know, to include things like overtime and regular allowances and commission payments and so on. Many employers changed the way they calculated holiday pay because of that, but some didn't. So those that didn't, the risk of how much you might have to pay if someone brings a claim has just grown because the 3-month gap no longer breaks that that causation, if you like. Now, this is especially a problem in Northern Ireland, where there's no 2-year limit to claims, whereas in Great Britain we have, you can't go back more than 2 years. So it will be, there is some light at the end of that tunnel, if you like. Then this is a case where a former Goldman Sachs employee who was fired after returning from paternity leave won a sex discrimination case. So these are relatively rare, where a man brings a sex discrimination case. But this person took extended paternity leave, which was a benefit that he was afforded by his employer, and then was told things like, you're a grown man, you can sort out how you deal with this, when he raised concerns about struggling to manage his work-life balance. He was eventually dismissed from his role straight after he returned from this 6 months paternity leave. So most only give 2 weeks paternity leave, but Goldman Sachs give up to 6 months paternity leave. And you don't necessarily need the details of this case. It's just the timing was particularly poor, because just before the end of that 6 month paternity leave, he was placed at risk of redundancy, then put on gardening leave, then dismissed. And the tribunal found, excuse me, that no attempt had been made to ensure any fair process was carried out before he was dismissed, and linked his dismissal to that 6 months of paternity leave. So payment, the remedy is yet to be determined, but this potentially could be rather expensive. So we will see what eventually is awarded. And then this case is a former council employee who was dismissed after taking sick leave, but this person took sick leave for post-traumatic stress disorder following the work they did as a result of the Grenfell Tower fire. And they were found to have a disability. Their PTSD, post-traumatic stress disorder, PTSD, was related to that fire and the work that they had done on that, and left them with a disability. And this was found that their dismissal after taking sick leave was related to that disability, discrimination and harassment. And they were awarded a record-breaking £4.6 million in compensation. So this person was sacked from the role, and the role was Director of Public Service Reform, very senior job. And, you know, well, it was actually 4.58 million was awarded in compensation, which is one of the highest, if not the highest ever, damages awarded. So again, the details aren't particularly important, but what is important is that we've got to take proper steps and make reasonable adjustments for people that have a disability. People have to be treated fairly, and we have to look at what we can do to support someone who, in this case, had taken sick leave in relation to their disability. So while the size of that award is eye-catching, it just highlights the fact that we, you know, just have to be really careful with how we deal with absences that relate to disability, and extending how long we might allow or support somebody in a return to work who has a disability is one of those reasonable adjustments. So I've mentioned it because it's a very significant sum of money, and really highlights the importance of fair process, I think. This is a pregnant account manager who was called emotional and tearful by her boss, and she eventually received a compensatory payment of £350,000. And this case of Hines and Mighty Limited, was all about considering the employee during their pregnancy and maternity leave and upon their return to work, and whether they had been discriminated against in a significant enough way to entitle them to resign and claim constructive unfair dismissal. So there were a number of factors. She was really, her boss decided that she was really struggling while she was pregnant, had some panic attacks, disrupted sleep. They were all concerned about her ability to do her job properly. And the tribunal found that the respondent should have considered altering her working hours, her working conditions, redeploying her to alternative work, and supporting her in a far more positive way than they had done. In fact, the judge said there was an obvious and pressing need for the respondent to complete a risk assessment. However, they failed to do that. There were also these quite rude emails that were sent, you know, about her being emotional, hormonal. It's pregnant women in the workplace was another one, you know, that, and they were found to be dismissive and belittling. So again, data subject access requests, information being disclosed. This is a good example of what not to do when dealing with a pregnant worker who is struggling with their job by reason of their pregnancy. Instead of providing support, you know, they provided an unsympathetic, insensitive, and rather, you know, dismissive approach towards helping her. Then I just wanted to mention this equal pay claim. We're going to run out of time soon, and I think we've just got a couple more really quick cases to tell you about. So Birmingham City Council have just settled their long-running equal pay case with 6,000 members of staff, and are likely to have to pay out 760 million. In fact, since 2012, that authority has paid out 1.1 billion in equal pay settlement cases. Next have also just significantly won an equal pay case as well, where the in-store employees, normally female, earning less than the out-store employees, normally male. And we've got Tesco's and Asda and Morrison's and lots of other major retailers with similar equal pay cases. So always keep an eye on equal pay in your workplace. Are people being paid fairly? This next case with National Grid is a sexual harassment case. Young trainee works for National Grid, and it has just been awarded £360,000 after a tribunal ruled in favour of her harassment. There were lots of examples. Her manager asked her to remove her jumper, made physical advances, invaded her personal space, and even proposed marriage, apparently. Despite an internal investigation, the perpetrator was not dismissed until she resigned and brought a claim. So a substantial amount of money on that case. In fact, the tribunal said their investigation process was perverse given the evidence. So they protected themselves instead of having a fair investigation, which should have upheld the harassment that she received. Well, we know losing employment tribunal cases can be expensive, and in this case, another big payout was made, 3.2 million, to an ex-employee after he won a direct age discrimination case. He'd worked for nearly 40 years when he was replaced by a younger person, and that was found to be age discrimination. So if you let someone go and you employ someone else, then you need to be really clear that there is no reason that discrimination might relate. The reason age was found here was that there was a very long conversation with this employee about, you know, pushing forward, modernising, a 45-minute lecture about we can't be old fossils, you know, learn how to deal with the millennials you manage, and so on, and relating all of that to the unfair treatment and the fact that they were replaced with a younger person meant this person brought a successful age discrimination complaint. Thinking about age, I'm just going to mention the highlights of these three cases. First case, the comments made were things like, well, back in your day, I expect it was done differently. That case failed. The second one was where an employee was offered a chair. They said that only an older person would have been offered a chair. That case failed. And the third one was where an employee was told that her trousers made her look frumpy. And that case failed. They all failed for different reasons. And in some, the tribunals have indicated in other circumstances, those type of comments would have the purpose or effect of causing someone to be upset and feel harassed and so on. So I'm definitely not saying those things are okay to do, because they're not. But there were 3 specific cases where the employee was unable to win, citing those kind of things. So often there's a collection of things that go on rather than just one particular thing. Last case I'm going to talk to you about, and we're not going to do the poll because we don't have time. What is dead naming? Well, dead naming is the act of calling a transgender or non-binary person by their birth name after they've chosen a new name. And many transgender people change name as part of gender transition and wish their former name, known as the dead name, to be kept private from there on in. So if you misgender or call someone by their dead name, then that's potentially outing them as transgender. And that's exactly what happened in this case with Kingston upon Thames. So where someone changes gender, chooses a different name, makes it clear that they want that to be the name used going forward, a failure to do so will be an act of discrimination, as was the case here. In fact, it took this employer nearly 2 years to actually get all the changes to pension and other benefits and all the things that this person wanted to only be in her new name. So be very aware if that's the case. And that's it. Dead on time, just about. I'm afraid we've probably run out of time for me to answer any other questions, but what I will do is ask for them to be sent to me with contact details, and I will send answers through. So apologies, we've run out of time for me to answer them live for you, but I will get back to you. And thank you very much for participating in the polls and for listening in to what's coming, what's been, what's coming, and some of those interesting cases as well. So have a great afternoon, and thank you very much.